You gave these documents to your lawyer to hide them, didn't you?
Maybe I can.
I'm not talking to you, Counselor. I'm talking to Mr. Karofsky.
No, not to hide them, Senator. We have not turned over the documents, Senator, because of the threat of litigation.
The threat of litigation. So that's what this is all about. You don't want to pay any more money, do you?
No,
And let the chips fall where they may, and then in front of God and country, if you owe more money, then by God, pay it. Because that's what this is about. It's all about the Benjamins. It was then, and it is now.
What happens when a senator confronts one of the world's biggest banks over money stolen from Jewish victims during the Holocaust and then demands to know why crucial documents are being withheld? Senator John Kennedy put UBS executive Robert Karofsky on the spot, accusing the bank of hiding behind attorney-client privilege and warning, if UBS owes more money, by God, pay it.
And several years ago, UBS bought Credit Suisse. Is that correct?
yes, Senator.
And in doing so, UBS assumed Credit Suisse's assets and liabilities, didn't it?
Yes, Senator.
Okay. Can we agree that when the Nazis would conquer a country during World War II, that the Nazis would take the people's money? Is that correct?
I'm not sure what you mean by that, Senator.
Sure you know what I mean. They took people's money, didn't they?
Yes, Senator.
And that includes the money of Jewish people. Is that correct?
Yes, Senator.
And the Nazis not only took their money, they took the hair from Jewish people and their teeth and sold them, didn't they?
Yes, Senator.
And they took the Jewish people's labor, didn't they?
Yes, Senator.
And ultimately, the Nazis took the lives of many Jewish people, didn't they?
They did, Senator.
And the Nazis took all this money and put some of it in Credit Suisse Bank, didn't they?
They did, Senator.
Why did Credit Suisse take this money?
Thank you for that question, Senator. UBS and Credit Suisse's conduct, behavior during World War II was terrible and shameful.
Why did Credit Suisse take this money?
They took the money to presumably profit from it at that time.
Yeah, Credit Suisse took the money because they wanted to make money off of it, right?
It seems so, Senator.
And not
The investigation continued after this February 3rd hearing. In March, UBS went to federal court seeking confirmation that the historic $1.25 billion Holocaust settlement protected it from additional Holocaust-related claims tied to the newly uncovered evidence.
Not only did Credit Suisse take this money, but Credit Suisse also helped many of their customers, Nazis, actually escape after Germany lost the war. Isn't that true?
Through the rat lines, yes, Senator.
Rat lines. They call them rat lines. Now, some in the Jewish community pointed this out to Credit Suisse. And Credit Suisse decided to hire Mr. Borofsky. Is that right?
Yes, Senator.
And Mr. Borofsky did his job, didn't he?
He has, Senator.
And in fact, he did his job so well that Credit Suisse fired him. Isn't that right?
Senator, I wasn't a part of those decisions.
Are you saying he did a bad job?
We are grateful for rehiring Mr. Borofsky, and he has done tremendous work.
Come on, Mr. Karofsky. Let's be honest here. You're under oath. They fired Mr. Borofsky, they meaning Credit Suisse, which you now own, because he was doing his job, didn't they?
I wasn't part of Credit Suisse at the time, Senator, so I am
Do you
unaware.
believe in the tooth fairy?
I do not anymore.
Do you believe in the Easter Bunny?
Not anymore, Senator.
Do you believe that Jimmy Hoffa died of natural causes?
I don't have a comment on that,
Of course
Senator.
they fired him because he was doing his job. And then UBS bought Credit Suisse, and UBS, kudos to you, you rehired Mr. Borofsky. Is that right?
We did.
and he's rocking along doing his job. Only he gets too close again. And UBS has decided to take some of the relevant documents, this is pretty slick, actually, and give these documents to its lawyer and claim attorney-client privilege. Isn't that right?
With due respect, Senator, this is our investigation, which is being supervised by Mr. Karofsky, and we have provided cooperation.
You didn't take these documents and give them to your lawyer because you wanted your lawyer to disclose them at a press conference, did you? You gave these documents to your lawyer to hide them, didn't you?
Maybe I can.
I'm not talking to you, Counselor. I'm talking to Mr. Karofsky.
No, not to hide them, Senator.
Oh, you didn't? Well, why'd you do it then? Out of the goodness of your heart?
No, as
in the interest of justice?
As my colleague mentioned, we've been fully cooperative.
You haven't turned over these documents.
We have not turned over the documents, Senator, because of the threat of litigation.
That document dispute escalated after this hearing. On April 7th, a federal judge rejected UBS's attempt to obtain advance protection from potential future Holocaust-related claims. Then in May, Karofsky told the Senate that UBS was withholding more than 22,000 pages from his investigation on privilege grounds.
Ah, the threat of litigation. Oh, I see. Now, Credit Suisse, before you acquired them, paid $1.25, I think, billion in damages to the Jewish people. Is that right?
That was a collective settlement from Swiss banks.
Yeah, but that doesn't account for any new evidence of crimes, does it?
It does, Senator. It's for known and unknown claims, and the larger portion is for unknown claims.
So that's what this is all about. You don't want to pay any more money, do you?
No, the $1.25 billion is for known and unknown claims.
So your position is that Credit Suisse, whose liabilities and assets you assumed, paid $1.25 billion, and you're not paying a penny more. Is that right?
So we also paid. It was a collective settlement, and the
But
settlement was final.
your position is you're not paying a penny more. Is that right?
That is correct, Senator. It was accounted for
So that's
in the
what
unknown
this is
claims.
still all about, isn't it? The money.
For
It
us,
was
it's
about
about
the money
finding the truth, Senator.
when your predecessor took the Nazi money, and it's about the money right now, isn't it?
I don't agree with that, Senator.
Oh, I see. What could it be about then? Principle? The sanctity of the attorney-client privilege? UBS, look, I don't hate anybody, sir. I want you to know that. But we all have a record. UBS got caught manipulating the LIBOR interest rate, didn't it? Had to pay $700 million for manipulating the interest rate. Isn't that correct?
Amongst other banks, yes, Senator.
UBS also got caught hiding the money of 52,000 Americans so they wouldn't have to pay taxes. Isn't that correct?
That was settled in 2009.
Yeah, you paid $780 million, didn't you, for doing that? Isn't that correct?
I'm not sure of the exact number, Senator.
I am. UBS also, just in recent history, decided to debank people whose politics you didn't like, didn't you?
No, Senator.
UBS said we're not going to do business with firearm-related companies or oil and gas companies and coal miners and crypto financiers, didn't you?
We provide fair access for...
But you debanked these people, didn't you? How noble of you. How wonderful it must be to be more righteous than the rest of us. Here's my advice, and then I'm going to hush, Mr. Chairman. I appreciate your indulgence. I don't have anything against the good people at UBS. But the smart play here for you is to release these documents and let Mr. Karofsky finish his report and let the chips fall where they may, and then in front of God and country, if you owe more money, then by God, pay it. Because that's what this is about. It's all about the Benjamins. It was then, and it is now.
In March 2026, Karofsky reported additional concerns about access to Credit Suisse archival records, while UBS argued that some materials were protected by attorney-client privilege. On April 9, 2026, UBS said it would not turn over a group of privileged documents after a judge indicated he could not guarantee protection from future lawsuits. On May 5, 2026, Karofsky told the Senate that UBS was withholding more than 22,000 pages from his investigation and had also limited the scope of the review while examining another 388,000 pages for possible redactions. UBS has defended its cooperation and said it has already produced millions of pages. That later development makes Senator John Kennedy's questioning of UBS executive Robert Karofsky much more significant. Kennedy was not simply asking about something that happened 8 decades ago. He was questioning whether the successor to Credit Suisse was being completely transparent about the historical record and whether today's UBS was willing to allow investigators to follow the evidence wherever it led. The central issue was trust. Credit Suisse's history during the Nazi period is already well documented, and UBS itself has acknowledged the shameful role Swiss banks played during the Holocaust. But the current investigation is examining whether the historical record was incomplete and whether additional accounts, transactions, and relationships remained hidden. That is why Kennedy repeatedly returned to one basic question. Why shouldn't UBS simply release the documents and allow the independent investigator to finish the work? Karofsky's position was that UBS was cooperating with the investigation, but that some documents could not be released because of legal concerns, including the threat of litigation and attorney-client privilege. Kennedy clearly saw that differently. From his perspective, invoking privilege at precisely the point where investigators are trying to determine whether additional wrongdoing occurred creates a serious transparency problem. His argument was essentially that historical accountability should not stop simply because revealing additional evidence might create financial consequences. That is an important distinction. The 1999 settlement involving Swiss banks resulted in $1.25 billion being paid to Holocaust victims and their heirs. UBS maintains that the settlement addressed known and unknown Holocaust-related claims. But the newer investigation is examining evidence that was not necessarily known when that settlement was reached. And that creates the difficult legal question now facing UBS. Does the old settlement completely resolve potential claims, or can newly uncovered evidence lead to additional accountability? UBS has argued that the settlement provides broad protection against further Holocaust-related claims. The Simon Wiesenthal Center and investigators have challenged that position, arguing that newly discovered evidence deserves to be investigated rather than automatically closed off. This is where Kennedy's criticism about the Benjamins becomes more understandable. His argument was not simply that UBS was motivated by money. He was pointing to a broader concern. If releasing historical documents could potentially expose a company to additional financial liability, there is an obvious incentive to fight over access to those documents. That does not prove that UBS is intentionally hiding evidence. And that distinction is important. UBS says it has cooperated extensively and has produced millions of pages. The bank has also said that its review is voluntary and that it wants to establish the historical truth. UBS's May 2026 response to the Senate emphasized that it has taken substantial steps to investigate Credit Suisse's World War II history. At the same time, Karofsky's complaints about restricted access show why senators remain skeptical. The investigation has identified potential links involving Nazi institutions and individuals, including the SS and entities involved in the looting or Aryanization of Jewish property. Karofsky has argued that examining those relationships is necessary to understand whether Credit Suisse played a role in facilitating Nazi criminal activity. The disagreement, therefore, isn't simply about whether UBS has cooperated. It is about how much cooperation is enough. If an independent investigator is given millions of documents but is denied access to a smaller group of documents that could be particularly relevant, does that constitute meaningful transparency? Or is the bank justified in protecting privileged material and limiting exposure to future lawsuits? Property, businesses, homes, bank accounts, and personal possessions from Jewish families. Financial institutions were part of that system in different ways. That means the historical record of bank accounts is not merely an accounting exercise. It can help establish how stolen wealth moved through institutions and who benefited. The newly identified accounts therefore matter beyond their individual dollar values. They could help historians and investigators understand how Nazi-linked organizations operated financially, how Jewish assets were transferred, and how some perpetrators were able to escape Europe after the war. The evidence regarding the post-war Ratlins is particularly significant. Karofsky's investigation reported that Credit Suisse had relationships connected to organizations involved in helping fugitives reach Argentina, and that bank accounts were allegedly used in ways connected to transportation, living expenses, and fraudulent documents. That makes the dispute over documents even more important. If records can establish who knew what, who moved money, and who benefited, then withholding those records can prevent investigators from completing the historical picture. But Congress also has to recognize the limits of its authority. Attorney-client privilege, court orders, and existing settlement agreements are legal issues that cannot simply be dismissed because senators want answers. That is why the dispute has moved beyond a political hearing and into the courts. The April 2026 developments showed that UBS's position remains contested, while the Senate Judiciary Committee has continued demanding direct answers from UBS executives. Chairman Chuck Grassley sent additional questions to Karofsky and UBS General Counsel Barbara Levi in April, specifically warning that the committee expected direct answers because the hearing record remained open. The investigation is therefore still unfinished. And that may be the most important takeaway from Kennedy's questioning. The issue isn't whether UBS should automatically be ordered to pay more money. The issue is whether the evidence should first be fully examined before anyone decides whether additional responsibility exists. Kennedy's closing argument was essentially that truth should come before the financial calculation. If additional evidence proves that more money is owed, then the responsible parties should deal with that consequence. If the evidence does not establish additional liability, then the investigation should make that clear as well. Either way, the public benefits from knowing what actually happened. The deeper significance of this hearing is that historical accountability does not have an expiration date simply because the events happened generations ago. At the same time, accountability has to be based on evidence, not assumptions. The question now is whether UBS will ultimately allow investigators unrestricted enough access to determine the full historical record, or whether legal protections and financial concerns will continue to limit what the public can learn. Should UBS be required to release every document relevant to the investigation, even if those documents could expose the bank to additional financial claims, or should attorney-client privilege and the 1999 settlement continue to protect the remaining records?